I'm talking, rather than the disasters at the end of a project, how to avoid them. And the most important thing you can do, in my opinion, beyond appointing good contractors to carry out the works, is having your good, clear, written contracts in place before you start. Before I get into the meat of my talk, though, just to introduce Lamb Chambers. As I said, Mark Rowlands is here, Chambers Director, and I am part of the Lamb Chambers Construction Group. There are 10 specialist barristers, and we advise at all stages of the construction process, be that written advice. Oh, this is speeding through. Try and stop that. Regularly act in litigation from the TCC, the Court of Appeal, and in county court disputes, and especially in adjudication. I don't know how many of you saw David Sawtell's last talk that he gave with So Legal, but he's recently been in the Court of Appeal on an adjudication case, Eigen and Grosvenor. So, really fast moving in terms of the work that Chambers is picking up. So today's agenda, first off, just talk generally about contract documents, what you should hopefully be including in your contracts, what you can be referring to as a helpful aid to interpretation, or just generally to outline what the project's going to be and what you hope to achieve through your development. And then on to three more legalistic issues, the first of which being grappling with the point of, if you're starting a project, you're halfway through or you've got to the end, was a contract ever concluded between the parties? Did you just proceed on the basis of an exchange of correspondence? Did you sit down and go through a JCT contract and say who's got responsibility for this and that? Then on to the issue of battle of the forms, as it's so called. A lot of the time you'll see contractors or suppliers engaging in a bit of a tit for tat in exchanging their terms and conditions and hoping one beats the other in some sort of concluding agreement, and how the courts grapple with those issues. And finally, on to the point of, if there is an agreement concluded or works are carried out such that there has to be some sort of agreement on issues, what things can crop up that you might not have thought of, that you might have obligations in respect of, that could give you liability that you wouldn't necessarily have thought at the outset. So the reason that I flagged this up, and you see people asking the questions all the time, well, isn't this just cost building at the start of a project? Why can't we just go, I've worked with this guy for a long time, or I trust his judgment to go off a start now and we'll deal with the legals later. But 4 key points really. The first, confusion. If you don't have detailed drawings in place, detailed designs, it can be confused over what you're actually attempting to build or renovate or do. Secondly, delay. Delays happen through a project. It can be helpful to know who's responsible for those. A contractor, if they know they're on the hook for delay in liquidated damages or similar, they might work to catch up, whereas it might not be in their incentive. If they don't think they're on the hook for a particular completion date, they might slow down. I don't say anybody in the room does that if you've got any developers in the room, but it's something to be aware of, and the importance of having those liquidated damages clauses in place. Third one is obviously costs. Although you're spending something in the front end and getting those contracts in place, costs at the end can be enormous if you end up in long-standing disputes. One in the Court of Appeal recently that I'll refer to was a contract concluded 11 years previously, and it ended all the way up in the Supreme Court over £50,000. And I can assure you the legal bill was a lot higher than £50,000 when it got to the end. And fourthly, relationship breakdown. If you don't have a good, clear contract in place, you're inevitably going to come into some sort of dispute, whether that's at the start, the middle, or the end. And you might work with this trader a lot, and it helps to have a clear outset of a relationship at the start. So on to the point of contract documents. Depending on your complexity, from a small residential renovation, say a loft conversion, up to large commercial fit outs or building indeed, they can either be several hundreds of pages or an exchange of 3 emails. You see the complete range of documents, and the point I'd make at the outset is really more paper doesn't equal more certainty. A lot of the time people think, oh, I've got this 5-page agreement, or I've got a letter of intent. Let's just add all the tender documents, let's add all the drawings we have and annex them to the back, and that'll help. That'll make it clear for everyone. In fact, that can make the situation worse. There have been countless decisions recently TCC, Court of Appeal, even the Supreme Court, MT Hogarth, where you realise something which was buried away in the technical specifications can end up being the reason why you're liable for something. So be really clear about, if you want to include a drawing or a document in the contract, what is that document saying and how does it help you clarify who's responsible for what? Because adding documents can actually make it more difficult to figure out who's agreed to do what. Again, consolidating and using clearly defined terms. If you're updating contracts, if you're negotiating particular terms, make sure your cross-referencing picks up. Missing a cross-reference can be incredibly important when it comes to a dispute. If you refer to clause 14 and you meant to refer to clause 11, lawyers love a fight about that. And then, the best way that I think to do it is to use the Jct Forms. I'm sure many people in the room are familiar with the Jct suite of contracts. They can be used for multi-million pound works, all the way down to minor works contracts, and even for subcontractors as well. And that can be a really helpful way of ensuring you've got a chain of liability all the way through from your main contractor, if you're the employer, into your subcontractors. Or equally, if you're a subcontractor, you know that there's a chain of certainty going back up as well, which can help you coming down the line in disputes, because you know the employer is going to be involved and bring you forward. So, contract or no contract. The courts have to grapple with this quite often, especially in construction disputes, because parties are keen to get on with the project. They don't want to waste, as they see it, a month or 2 months going through, who's going to be responsible when it goes wrong, because you're starting off on a positive foot. You think, this is just doing this house to how I want it built, let's get on with it. And you see exchanges of correspondence, and that ends up, when the dispute happens and when the building's been built, there's no agreement in place. So figuring out who's responsible for what can be really quite difficult. Now, I've put on the slide there, if no services are carried out, the court are more likely to take the view that there's no binding agreement. That's not a hard and fast rule. And as lawyers love to say, it will depend on the circumstances. But it is very important to note that even if you go through an entire project, the courts might find that there was no contract concluded at all. And a contractor, although you priced up for a bid of, say £100,000, and it stopped halfway for some reason, you're only entitled to the work you did. So you might end up out of pocket, and you only receive the expenses you've incurred on a quantum merit basis. So the courts have set out in Pagnan and other cases the sorts of things that the courts are going to be looking to decide whether a contract's been concluded or not. The point being, you've got to look to the negotiations as a whole and see whether there was a traditional sort of offer and acceptance analysis. There being a clear offer saying you can accept by signing on this dotted line, and they signed back, clear as day, you've got a contract. But what if there's an email saying happy to proceed? Does that, or I'll proceed subject to our legal teams talking? You've got to be clear in what you're saying to your contractors or to your subcontractors. Be clear in what you're committing to, whether it's a fee proposal, whether it's a full contract document, or terms and conditions on the back of an order sheet, which you see all the time. The other points, it shouldn't be expressly subject to contract. That would stop a contract forming, but not always the case. And the courts stress, I think, a lot of the time about essential terms. So in contract disputes, you'll often need a price, you'll need a start date, possibly a finish date, but not necessarily, and a general setting out of what those works are. Parties can express what they consider to be essential. So a party might say, I'm not going to sign on, we're not agreed until we figure out the amount of liquidated damages. That could prevent a contract coming into place. So do be really clear at the outset what your red lines are, because that can help you coming down the line in saying, I didn't agree to these terms, I've got here in this clear correspondence between the parties, saying I wasn't willing to sign up to that. I'll probably skip that quote if that's all right with everyone. I don't want to bore anyone. But it just goes through the overall principles that it's not looking to your subjective mind at the time. What the courts have to do is read the correspondence, if that's all there is, or read the exchange of contract documents and say objectively, me as a judge or as an adjudicator, what was agreed on the face of these documents. And it becomes very difficult to even remember from 4 years ago what I meant by that particular word. So be really clear as best you can in what you're signing up to. I already referred to this case, but I do think it's very helpful in showing why it's so important to be really clear, get a written contract in place. It was a Supreme Court case of Wells and Devani. It was a dispute between an estate agent and somebody trying to seek commission off an introduction off the back of it. It was a dispute about £50,000 because it was 2% of a £2 million development. The contract was concluded in January 2008. It only got decided by the Court of Appeal 2 weeks ago. So it's taken 11 years of lawyers wrangling over whether there was a contract for £50,000. And like I said before, you can imagine the lawyers' costs were a lot more than £50,000 going through that process. And also everybody's kept out of pocket. Obviously in the construction context that might not happen because of adjudication, but if you've got a residential project where the Construction Act doesn't apply, you can certainly end up in these long-winded battles about contract, no contract.
Did the estate agent win?
The estate agent did win, yeah. So he won in first instance, lost in the Court of Appeal, and then the Supreme Court overturned that. So again, it can show just how difficult it is to construe those contract, no contract cases. And in the Court of Appeal, it was Lord Justice Lewison who wrote the book, Contractual Interpretation. Lewison on the interpretation of contracts, and yet he was overturned in the Supreme Court. So it just goes to show, if you're relying on, oh, we shook hands on it in a room, how long that can take to sort out what you really meant, or whether there was an agreement at all, really can tie you in knots, and tie the courts in knots as well. Now, one way parties try and get around this in the quick snapshot way is what's called the Battle of the Forms, which is essentially you've got an order sheet and an order acknowledgement, both of which have terms and conditions on the back, both of which are saying these will prevail over the other. Now, the way the courts approach this generally is whoever gets the last shot, provided it was accepted either by conduct or by signing on the dotted line, you've signed up to what that agreement says. And it can have quite drastic consequences. Butler Machine Tool and Excello was a case about the provision. Sorry, let me get these facts right, because they're quite similar between the two. Butler Machine Tool. So Excello were trying to buy milling machines from Butler. Butler sends a quote saying, I'll price up for about £7,000 subject to my terms and conditions. Now, this included a price variation clause which said if the price of these machines go up before they're shipped, we get the excess costs. The Excello respond and say, we'd like to accept your quote of £7,000 subject to our terms and conditions. And it had a signing sheet at the bottom. Butler signed the terms and conditions signed this order acknowledgement form when the goods were delivered, and when the goods were when the goods were signed for, and when they were actually delivered, the price had almost doubled. And Excello say, well, no, it's £7,000. That's what we agreed. That was the amount. And Butler say, no, we only offered on the basis of our terms. But the courts held that because they'd signed the last shot from Excello, that original offer fell away. So it's really clear, if you're going to be signing an acknowledgement slip, a document without your written contracts in place like we've been talking about, be really clear what the terms and conditions you might be signing up to. Because again, especially in the supply context, you see it all the time with order confirmations or order acknowledgements trying to assert their own terms at the very last minute. Be really wary of that, because they can often include liquidated damages clauses, price variation clauses, which can really be the sting in the tail. And that point about at the very bottom there, or on this slide, sometimes the order acknowledgement forms or the order confirmations can try to say, well, any future terms you try to impose are null and void, they won't apply, this prevails over any future terms. But those will almost invariably be struck out on the basis that you can't bind the hands of future negotiations. If there are counter offers that come the other way, it'll extinguish previous offers, and that's a general contractual rule. Again, can depend on the way it's drafted, but you'd have to be slaving over that clause for hours to make it enforceable. Tech Data was another case dealing with the same issue. Again, the forms go backwards and forwards, and they tried to rely on the fact that they'd known the guy for 20 years. We've always contracted on these terms. He only sent this form on this one deal. Surely that doesn't affect the way we do business. The court say, no, you've signed this document, that's the contract. So even if you've got a long-standing relationship with someone, be wary each time you're signing an order form, because you might be signing up to something you weren't expecting. Now, what if we get through the whole process of negotiation and we think, no, let's just get on with it. I trust the guy. Let's do it on a simple contract. Here's the price. Here's the works. Let's go. At this point, when a dispute arises, the courts are going to be looking to imply terms into an agreement. And this is where the lawyers really start rubbing their hands because you can have some serious fun, not only through the litigation process in the courts, but especially in adjudication. So if there are any commercial developers in the room, you'll obviously be aware of the Construction Act and the adjudication regime. And often those adjudications are presided over by non-lawyers who might not be as sharp on the requirements I'm about to go through on necessity for those terms. And I actually won an adjudication last year on the basis of an implied term that an employer took ground risk on the basis that he needed to comply with the CDM regulations. Now, in a court that wouldn't have flown, but in an adjudication it does. So you can really get caught out by implied terms. And the general rule on implied terms, you've got two types. Those implied by law, such as the Construction Act, or if you're dealing with residential, probably the Consumer Rights Act, dealing with obligations of reasonable skill and care, etc. And then those implied by fact or circumstances. There's a quite legalistic three-stage test about whether that term is necessary in the circumstances, which is quite a high bar to reach. But again, in the construction context, there are very specific reasons why these implied terms arise. The most notable ones I've tried to sort of pull up on the screen here. Reasonable care and skill, everybody knows, if you're acting as a construction professional or a developer, you've got an obligation to act in a reasonable manner and the reasonable developer. In the residential context, especially fitness for habitation can be quite a big point, either implied by law under the Defective Premises Act or by common law if you're building a house for a consumer. Completion within a reasonable time. If you haven't fixed your completion date, there is an obligation with you to get on with the works. You can't sit on your hands, or you could end up being liable for not completing. If you're an employer and you're pushing through developments, you've got an obligation not to prevent the contractor from getting on with things. So not holding up the supply chain because you run out of cash. That might leave you on the hook. And also generally payment terms. Like I say, if you're in a Construction Act situation, commercial development, there are very clear terms on notices you have to give when you're applying for payment, either on an interim basis or a final basis. And you can be on the end of adjudications where you just haven't filled the notices in and you're on the hook, and then you have to go back through litigation over everything when the money's in the other party's hands. So do be really clear on your payment terms as well. And like I said, I've flagged up that CDM regulations, or it could be compliance with planning. You might not have had an involvement as a contractor in the planning process, but then suddenly there's an implied term you had to comply with the planning that you had no hand in. So that can be really important to really think about those things. So just to wrap up, my sort of top tips when entering into negotiations or entering into a contractual deal over a construction project, always try to reduce your contractor writing. There's not an assurance anymore that you won't end up in an adjudication, because adjudicators can go over oral contracts as well now. Get the parties, if you can, to acknowledge what are the applicable terms and conditions, especially on the supply side. Really get signatures in place where you can. I know it's difficult, when you're trying to get on with the project and get things done, but it is really very important to get certainty over what terms apply before you even get into trying to interpreting them. Be aware of your implied obligations. I don't think that it's all within the square four walls of the contract. It can certainly go outside, but I couldn't recommend highly enough the JCT contract. It might seem overbearing, the hundreds of pages, but it can really help provide a clear framework for the parties to work, and it can be used again and again in projects with minor tweaks on the attachments that you add to it. Now, this is a recent video from Liverpool. Now this is what you call a smash and grab. This was a contractor who was out of pocket for £600. He said he didn't get paid over the Christmas period, and so he was going in. Now I would say that really is a smash and grab. But the important thing to note here is the parties have to be really, really clear about what your payment obligations are. I mean, he went through that thing. He got passed through reception, he got down the main lobby hallway, causing tens and tens of... So, first,
I think the important thing is no one's actually tried to stop him.
no, you went, but just to finish off on that example from Liverpool, he'd actually been paid. He got paid that morning. He'd been paid at 9 o'clock and he did that at 10 o'clock in the morning. So he hadn't realised the difference. What he'd missed out is the difference between working days and clear days, and had ended up literally over £600. So really be clear with your subcontractors, whether it's just your forklift operator or anyone can end up ripping stuff out. I know that's quite an extreme example. You see it all the time with subcontractors who say, I've not been paid on time, or what I consider to be on time. Let's go smash up the works I've done, or rip out the plumbing that I've done. You see it all the time, so really do be as clear as you can. And it's an extreme example, but I think it serves the point very well. That's the end from me. So on a good disaster, that's the end from me. Has anyone got any questions?
What we see a lot, we've got a couple of issues at the moment, particularly with agents, if there's any agents in the room, where, and you touched upon it there, where you have your set terms and conditions and you've used them for a significant period of time, and then what happens is when you have a dispute with somebody, and in particular it's people that you've dealt with for a long period of time where they don't sign the terms and conditions and send it back.
Yeah.
So your letter to them and your terms and conditions state, by signing this you've agreed to these terms, but maybe you've dealt with someone for 20 years. So on our terms and conditions, for example, we've got a provision that in the client engagement letter that points out that if you continue to instruct us but you don't sign the terms and conditions, you are bound by those terms because they're attached here. So
Yep.
we try to cover our backside. We've got a claim at the moment, it's over £100,000 for a client who is an agent who didn't get anything specifically in writing, dealt with that guy for this period of time. So you do have to obviously get these in writing.
Definitely.
But what happens in particular when somebody else has got a set of terms and conditions that they've dealt with for that period of time, and you're the agent, and you've said, well, you've been dealing on these terms for all this period of time.
Yeah.
This is where.
Well, that's the exact problem. Especially, the tech data case was a perfect example where you had these parties working together for 20 plus years, exchanging components. It was a Rolls-Royce aerospace contracts, and it was all about getting this component, and it all went wrong. The one way you can really do it is start again. Have a master framework agreement in place. That can be very helpful.
Which so legal can draft for
there you go. But definitely, actually, that's one point that was raised in tech data, is if you've got a supplier you use a lot or a contractor, a really nice way of tying everything together is have a good framework agreement in place, and all the projects sit as subcontracts under that. So each time you don't have to go through the rigmarole of what's the liquidated damages clause is going to be arising. All you need to do is say, refer to clause 4 of the framework contract, the liquidated damages for this project are going to be £10,000 a month, or whatever they are, and you can tailor it that way, which is a way of making sure you've got the written contract but not having to go through everything at each stage every time you're dealing with someone.
And the final, what you touched upon, we see it a lot, and there's obviously a big developer in Eastbourne has gone into liquidation, which people from Eastbourne will know. And we've had subcontractors. And this is the classic scenario where you've got the landowner, you've got the developer who signs the contract with the landowner, and then you've got the subcontractors. They've got no contractual relationship with the landowner, and the developer goes bust, but the landowner's either paid or not paid the development company. This is where we are. And you said retention of goods and the retention of work clause, non-parlour clause.
Yeah.
So the right for whoever's done the work, the subcontractor, to then say, well, that's actually my plumbing, that's my copper, that's my pipe.
Because it's not paid. Yeah. exactly.
You're walking down a really slippery slope there, trying to argue that case.
Yeah, definitely. And those build costs, it's costs you don't get back. So if you're in the context where you think somebody might be ending up in liquidation, there might be problems, and if it's a commercial project, get your adjudication in. You know, get your payment application in time. If there's no pay less notice, get on with it and adjudicate. Or even if there is a pay less notice, you can adjudicate. You've got 28 days. You'll get a decision which the courts will almost invariably enforce. I mean, you can come along. You've already touched on our nuts and bolts seminars about adjudication, but that can give you a really good introduction to the adjudication process. But that's a good way to get cash flowing. If you're a subcontractor and you're uptight up against a big developer, the adjudication process really does bring the balance of powers back together, and can be a really useful tool in getting that money.
It's tough times though, isn't it? I mean, you know, they don't want to bite the hand that feeds them. A lot of these subcontractors, they're small 1 or 2 man bands, and I don't know. We've seen 3 or 4 developers go bust recently, so it's definitely worth paying attention to this, because these are the things that are obviously going to come in the next couple of years. I think. I'm not saying Brexit's going to be the cause of that, but the next couple of years you're going to probably see a lot of adjudication, a lot of people trying to chase potentially dead money and trying to find out how to do that. So,
definitely.
Yeah.
And also that's the one point as well. If the developer's ending up going bust and you're sat there as a subcontractor, the employer might come after you, because you're the only person left in the chain.
Yeah.
So if they say, well, developer's gone bust, I'm not going to get anything out of the liquidator, I'll go after the subby who did the screed or something, and say that there's some horrendous defect in that you're then liable for all these delays and all these problems. So it is really important to know your rights and know your liabilities as well.
Brilliant. Well done, Ryan. That's great.
Thanks very much.
Thank you very much.